One thing we've seen through the long history of my channel is the corruption of the SDNY. Oh, we talked about the big ones. We talked about Martha Stewart. We talked about Ross Ulbricht. And more recently, we've been talking about them in the AI cases, particularly with OpenAI, which is together in this NRAY OpenAI case. They're still separate cases, but that's what the NRAY thing is. It's just a bunch of them together. Because they're basically the same case, and they make the same motions and get the same rulings, and of course, they've been relying on the corruption of the SDNY, and in particular, Magistrate Judge Onity Wang. Oh, we've been talking about hers. And one in particular one we talked about was basically when she allowed the plaintiffs to pierce attorney-client privilege and get OpenAI's communications with their lawyers. And that's something that is supposed to be sacrosanct. You're not supposed to be able to intrude on that, with a very few exceptions. Well, fortunately, Wang is just the magistrate judge. The presiding judge is Stein, and as you heard me say, well, we'll see how he is. Well, turns out at the very least he's not as corrupt as Wang, because he just overruled her big time. So this you probably won't hear about in the news because it's a win for an OpenAI, or at least the removal of a major loss for OpenAI. Because he completely overruled her, and if you read this, you get some choice examples of how one judge can put another judge in their place without having to do insults or anything, just like with legal speak. Things that might seem dry to you and me are really spicy when judges talk to each other. So we'll get into this. If you recall, Judge Onity Wang, on November 24th, 2025, gave a discovery order determining that OpenAI waived attorney-client privilege regarding the reasons OpenAI deleted the Books 1 and Books 2 datasets. And this is what they're trying to get, because by deleting the datasets, according to the plaintiff, that's proof of willful infringement. Oh, see, they knew they were doing something wrong. They got rid of the evidence. It's spoliation. Whereas if you remember in Anthropic, they've gotten in trouble now, and the only reason that case is still alive because all of the AI stuff is out of Bart's v. Anthropic. Because it's all fair use, including downloading and using those data sets for the purpose of AI training. It's only still alive because Anthropic retained the data sets. And that made it a shadow library or whatever, because it could be used for other things. And Anthropic was like, but we're only an AI company. That's the only thing we can use them for. But that's why that settlement is still going on. But the point is, if you keep the data sets, that invalidates fair use, apparently. But deleting them is proof of willful infringement. You better not keep them, and you'd better not delete them either. You see the Morton's fork they try to worm in? Because they know they're losing on the fair use issue. They know this is absolutely 100% fair use. And that's why they have to resort to all these dirty tricks. So the court concludes that the November 24 order is clearly erroneous or contrary to law. Simply put, OpenAI did not disclose material protected by the attorney-client privilege. In addition, OpenAI did not change its position regarding whether legal advice concerning the deletion of Books 1 and Books 2 is privileged. So waiver is not an appropriate sanction on the theory that OpenAI made a moving target of its privilege assertions. And OpenAI did not put its state of mind at issue merely by denying the consolidated class action complaints allegation that OpenAI willfully infringed plaintiffs' copyrights. So OpenAI did not effect an at-issue privilege waiver. The court therefore sets aside the November 24 order. Yep, they were trying to say that simply denying it meant they can pierce attorney-client privilege. We'll get there. In opposition to a motion by class plaintiffs, OpenAI repeated that the Books 1 and Books 2 datasets were deleted due to non-use, and that phrase is going to be important, before any litigation had been filed against OpenAI, and noted that OpenAI was attempting to locate any existing copies of the datasets. And then they found a couple of copies, but then plaintiffs said they were incomplete. But if it's done before there's any litigation and you don't know you're supposed to keep them, how can it be spoliation of evidence? Well, I mean, what they were basically saying was, oh, well, we were done using them. And that, according to the plaintiff, means you give up attorney-client privilege. Just by saying that. Fortunately, Judge Stein is not having it. Class plaintiffs moved for an order declaring that non-use was not a privileged reason for the deletion of Books 1 or Books 2, or that any privilege over the deletion of books 1 and books 2 due to their non-use had been waived based on OpenAI's prior disclosure of non-use as a reason for the deletion of the datasets. OpenAI opposed that motion on the basis that the reasons for the deletion are privileged, although it has also stated that it would not block plaintiffs from exploring the question of non-use of the dataset to be a cause of the deletions. Class plaintiffs then served a new deposition notice regarding the following topic: all reasons why each version of Books 1 and/or Books 2 was deleted, including non-use. OpenAI objected on the grounds that it called for privileged information, with the plaintiffs contending that OpenAI had waived the attorney-client privilege by disclosing non-use as a reason for the deletion, or alternatively, that the crime-fraud exception to the attorney-client privilege applied. So according to them, if you give a reason at all, then they get to look into attorney-client privilege and see all the communications between you and your attorney to see if that was the real reason. And that's bogus. In opposition, OpenAI asserted that it had consistently explained that there are no non-privileged reasons for the removal of Books 1 and Books 2. Judge Wang found that OpenAI had waived the attorney-client privilege over communications in 2022 regarding the reasons for the deletion of Books 1 and Books 2, and in 2022 referencing LibGen. Her order articulated 3 rationales for this finding. First, she assumed, based on OpenAI's position that all reasons for the deletion of Books 1 and Books 2 were privileged, that non-use was therefore a privileged reason for the deletion of Books 1 and Books 2, and found that OpenAI had impliedly waived the attorney-client privilege over communications related to the deletion of the datasets by disclosing non-use as a reason for the deletion. Second, she found that OpenAI had waived privilege by making a moving target of its privilege assertions. See if you can follow this. They initially stated, without equivocation, that Books 1 and Books 2 were deleted due to their non-use. They then asserted that all of the reasons for the deletion of Books 1 and Books 2 were privileged, then claiming that not all aspects of the reasons for deletion were privileged, including the question of non-use as a reason for deletion, and then asserting again that all of the reasons for the deletion of Books 1 and Books 2 are privileged. Alright, so they say, we deleted them because we weren't using them anymore. And they said, okay, we need all of your communications regarding that. They're like, what are you talking about? That's privileged. Oh, are they all privileged? Yeah. Well, you gave us non-use. Is that one privileged too? Well, okay, I guess if you include non-use as a reason, then okay, not all of them are. That one isn't, but the rest of them are. Aha, so now you're saying they're not privileged. No, they're all privileged. It's like debating with a creationist or a flurf. Oh my God. Because that's exactly what these people do. There's no reason. What about this? That's not a reason. Yes, it is. Well, okay, if you consider that a reason. Aha, you said there wasn't a reason. We've all had debates like that, haven't we? She found that OpenAI had waived the attorney-client privilege by putting its good faith at issue when it denied the allegations in the consolidated class action complaint that OpenAI had willfully infringed class plaintiffs' copyright. So a mere denial of their allegations becomes a good faith claim that then opens the door to attorney-client privilege. So a good faith claim might be, well, why did you do that thing? Well, I thought it was legal. Why did you think it was legal? Well, my attorney told me so. Aha, that's one of the exceptions. If you're going to rely on that, then of course those particular communications that relate to that and only that very, very narrowly, those come into issue so they can see what you were told. But according to Judge Wang, merely denying allegations is enough to open the door wide for attorney-client discovery. Also, the crime-fraud exception to attorney-client privilege did not apply because any communications about the deletion of Books 1 and Books 2 necessarily must have taken place after the alleged crime of torrenting pirated books. So they did the thing, they did the deletion, and then they talked about it. The November 24 order also rejected class plaintiffs' argument that the crime-fraud exception applied on the basis of alleged spoliation simply because they deleted Books 1 and Books 2. Alright, are you ready for the smackdown? Each of the bases for the November 24 order's finding is clearly erroneous or contrary to law. That might sound like a dry opinion. It isn't. This is Judge Stein saying to Judge Wang, "You screwed up, lady." First, the statements in OpenAI's letters that Books 1 and Books 2 were deleted due to non-use did not reveal any privileged information. Accordingly, OpenAI did not waive the attorney-client privilege by disclosing privileged information. OpenAI statements that they were deleted due to non-use do not reveal any legal advice from an attorney to OpenAI. The statements therefore did not disclose any privileged communications. Because the statements about deletion due to non-use are not privileged, those statements cannot be a basis for finding that OpenAI waived the attorney-client privilege. Duh. Second, OpenAI did not make a moving target. OpenAI consistently asserted that any communications between OpenAI and its attorneys seeking or providing legal advice regarding the deletion of Books 1 and Books 2 were privileged communications. OpenAI has never asserted that its statements about deletion due to non-use, which were made in the context of letters regarding OpenAI's document collection efforts, are protected by attorney-client privilege. Third, OpenAI has not put its state of mind regarding the legality of its conduct at issue merely by denying class plaintiffs' allegations. OpenAI simply denied the allegations of willfulness. OpenAI has not asserted a good faith defense. The order nevertheless found that OpenAI has put its state of mind at issue because for OpenAI to deny that it willfully infringed class plaintiffs' copyrighted works is to argue that it acted in good faith. That conclusion is contrary to law and basic logic and basic English grammar and everything else. That conclusion is contrary to law. That's a judicial dope slap from Stein. There is a distinction between a copyright defendant merely denying allegations of willfulness on which a plaintiff bears the burden of proof and a copyright defendant affirmatively asserting its good faith belief that its actions were lawful. OpenAI has not asserted a good faith defense merely by denying class plaintiffs' allegation of willfulness, and OpenAI has represented that it will not offer evidence of its state of mind regarding the legality of its conduct to rebut class plaintiffs' allegations of willfulness at trial. OpenAI thus has not effected an at-issue waiver of the attorney-client privilege by affirmatively relying on materials over which it asserts privilege to make its defense. And there's a point down here in a footnote below. As set forth above, OpenAI has explicitly and unambiguously stated its intention to forego asserting a good faith or state of mind defense, because those are completely irrelevant to fair use, as we've talked about several times before. OpenAI need not, however, forego any factual arguments in opposition to class plaintiffs' allegations of willfulness to avoid effecting an at-issue privilege waiver. There'd be no way to defend themselves otherwise. Such a waiver occurs only when a defendant relies on privileged advice from his counsel to make his claim or defense, such as by claiming a good faith or state of mind defense. OpenAI ultimately turned over to class plaintiffs copies of those datasets that it had recovered. Class plaintiffs had failed to allege a sufficient factual basis for their contention that the crime-fraud exception should apply on the theory that OpenAI's destruction of Books 1 and Books 2 datasets, despite substantial legal uncertainty, constituted spoliation. Accordingly, the court sets aside the November 24th order. No. Done. You don't get to break attorney-client privilege. That's another good one from Judge Stein. These things might be starting to turn around. I mean, in the less corrupt jurisdictions, they've pretty much found fair use right off the bat. We've got the SDNY. We've got the Central District of California, where Hollywood has the fix-in. So those are the ones where the real drama is. And then we'll see about the others, like the Suno cases in Massachusetts, things like that. But they're starting to go in the right direction. This is a good sign. At least that the plaintiffs aren't going to be able to continue getting away with whatever they want, and the judge just signs off on them. This isn't just a ruling against Judge Wang, it's a message to her. So we might see the nature of her rulings change a little bit after the judge overrules her like this. But we'll keep looking at it. Stay tuned if you want more updates. And please, comments for the comment god, shares for the share throne. Please hit like, subscribe, and the bell. And of course, donate.bogosity.tv. All sorts of ways to give. I finally got the Cash App link up there on the donate site for those of you who have wanted to use Cash App to send a donation my way. Of course, all the cryptos, and as well, Patreon, subscribe, star, Discord to become a regular supporter, get these videos early and ad-free, and other benefits, so please check all that out. Thank you so very much for watching. Until next time, stay strong and be free.